Welcome to our very first legal talk for 2023 with Hahn and Hahn attorneys. It's time to discuss legal matters again, and always interesting to hear about new topics. The first one that we're starting this year with is, why should I pay estate levies and what happens if I don't? And joining us from Hahn and Hahn attorneys is Bianka Oosthuizen. Bianka, it's the first time that we're chatting to you. Hello and welcome.
Hi, Ian. Thank you for inviting me to be on today's podcast. I really appreciate it. So thanks for the invite.
That's a big pleasure. It's nice to have you, and very interesting to know about the answers that you'll be giving us today for this topic. The first question, why should property owners pay levies towards an estate?
So, Ian, sectional titles and full title estate levies are paid to cover the costs of maintaining common areas of the estate, such as gardens, roads, and amenities that are shared by all residents. These levies also cover the cost of administration, such as the management of the estate, the payment of any levies, of any salaries or fees to staff, and the cost of any legal or other professional services. They are also used to cover any unexpected maintenance costs that may arise. These levies help to ensure that the estate remains a safe, attractive, and well-maintained community for all its residents. The successful levy collection of a sectional and full title estate is a crucial factor in maintaining the value of properties within the estate. If these levies are not collected, the value of the estate can be negatively impacted. Bad debt can have an even more pronounced impact on the value of the estate, as it reduces the amount of money available for improvement and repairs. This impacts the value of properties of other members within the estate that are paying their monthly levies.
Okay, Bianka, you mentioned sectional title and full title estates. What is the difference?
Ian, they are typically distinguished through the type of property. A sectional and full title property. Full title is the transfer of full ownership rights when you own property, meaning it includes the building and the land on which it is built. Examples are freestanding houses and small holdings. As the name suggests, sectional title describes separate ownership of units or sections within a complex or development. When you buy into a sectional title development, you purchase a section or sections as well as an undivided share of the common property. They are collectively known as units. Sectional title dwellings include semi-detached houses, townhouses, and flats or apartments. An estate that consists of full title homes belong to a homeowners association, while sectional title estates are governed by a body corporate. The homeowners association or body corporate is responsible for the management of the estate. And every homeowner becomes a member of the estate on registration of the title deed in his or her name, and they typically agree to the estate rules in the title deed.
Okay, now Bianka, who determines the amount that members have to actually pay?
So both types of these estates are governed by legislation. Body corporates are governed under the Sectional Title Schemes Management Act, and homeowners associations are regulated under the Companies Act. Both are required to produce audited financial statements. Body corporates have a board of trustees, and because homeowners associations are regulated under the Companies Act, they have a board of directors. Members normally nominate themselves to be on the boards, and the members of the estate will then vote for these members to act on the board. After the yearly budgets have been finalized, the board will propose a monthly installment. It could either be via an increase or decrease, or the monthly levy will remain the same. This is normally discussed at an annual general meeting, and members get the opportunity to vote. But your monthly levy will be highly dependable on the budget, as the estate will have to be in a position to cover its expenses. Any changes to a monthly levy must always be communicated to all members within the estate, and access to copies of financial statements, budgets, and minutes of meetings held should be made available to all members.
Okay, and are municipal rates included in this monthly levy?
So that's actually a very good question, Ian, and people normally get very confused. So some members are under the impression that their monthly levy will include their municipal bill, and that they are not liable to make any direct payment to the municipality within the area. It's not always the case. We typically see that these costs are included with sectional titles. But again, it depends on the specific estate, and the infrastructure involved also plays a role. It is advisable that when a potential homeowner wants to buy within an estate, or maybe if you are a homeowner within an estate and you are unsure, to rather communicate with the relevant body corporate or homeowners association that will clarify these expenses to you.
Okay, and now for the big question that we're ending off with today, Bianca. What will happen if I do not pay my levies?
So members are legally obligated to pay levies, and therefore an estate may institute legal action against a member who does not pay levies. The owner of the property remains responsible regardless of any agreement the owner may have with a tenant if the property is being leased. A body corporate is obligated in terms of legislation to provide a member with a notice first to inform the member that they are in arrears with their levies, and that if they do not make payment, they may proceed with legal action. But generally that will happen with body corporates or homeowners associations. It's typically a letter of demand to inform the person that legal action will be instituted if you do not make payment. So once judgment has been obtained in the matter, the estate can then apply for a warrant of execution and then give the sheriff instruction to go and execute the said court order against movable property like furniture, etc., to the value of the judgment amount. In extreme cases, the estate may bring an application for the property to be declared specially executable, meaning the court grants an order that the property be attached by the sheriff and sold at an auction. So, Ian, as you just heard, paying levies is very important, and it may have unintended consequences for other members of the estate and not just for the member who is not paying.
Yeah, I never knew that. That's very interesting. And that's our first legal talk for 2023 with Hahn and Hahn attorneys. That was Associate Attorney Bianka Oosthuizen. Thank you so much for your time and for shedding some light on the matter, Bianca.
It's only a pleasure. Thank you very much, Ian.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.